Now, let's talk about the special requirements for certain importations. The importation of certain classes of merchandise may be prohibited or restricted to protect the economy and security of the United States, to safeguard consumer health and well-being, and to preserve domestic plant and animal life. Some commodities are also subject to an import quota or a restraint under bilateral trade agreement and arrangements. Many of these prohibitions and restrictions on importation are subject, in addition to customs requirements, to the laws and regulations administered by other United States government agencies, with which customs cooperates in enforcement. These laws and regulation may, for example, prohibit entry, limit entry to certain ports, restrict routing, storage, or use, or requirement treatment, labeling, or processing as a condition of release. Customs clearance is given only if these various additional requirements are met. This applies to all types of importations, including those made by mail, and those placed in foreign trade zones. The foreign exporter should make certain that the United States importer has provided proper information to 1. Permit the submission of necessary information concerning packing, labeling, etc., and 2. That necessary arrangements have been made by the importer for entry of the merchandise into the United States. It may be impracticable to discuss all articles specifically, however, various classes of articles are focused here in this section. We'll talk more in detail about these classes in a moment. Foreign exporters and U.S. importers should consult the agency mentioned for detailed information and guidance, as well as for any changes to the laws and regulations under which the commodities are controlled. Now, we are going to go over the special requirements relating to certain agricultural commodities. First, let's talk about cheese, milk, and dairy products. Cheese and cheese products are subject to requirements of the Food and Drug Administration and the Department of Agriculture. Most importations of cheese require an import license and are subject to quotas administered by the Department of Agriculture for an agricultural service. The importation of milk and cream is subject to requirements of the Foods, Drug and Cosmetic Act and the Import Milk Act. These products may be imported only by holders of permits from the Department of Health and Human Services, Foods and Drug Administration, Center for Food Safety and Applied Nutrition, Office of Food Labeling, and the Department of Agriculture. Certain agricultural commodities, including fresh tomatoes, avocados, mangoes, limes, oranges, grapefruit, green peppers, Irish potatoes, cucumbers, eggplants, dry onions, walnuts and filberts, processed dates, prunes, raisins, and olives in tins, must meet United States import requirements relating to grade, size, quality, and maturity. These commodities are inspected, and an inspection certificate must be issued by the Food Safety and Inspection Service of the Department of Agriculture to indicate import compliance. Let's talk about the requirements relating to insects. Insects in a live state, which are injurious to cultivated crops, including vegetables, field crops, bush fruit, and orchards, forest, or shade trees, and the egg pupae or larvae of such insects are prohibited importation except for scientific purposes, under regulations prescribed by the Secretary of Agriculture. All packages containing live insects or their eggs, pupae, or larvae, which are not injurious to crops or trees, are permitted entry into the United States only if covered by a permit issued by the Animal and Plant Health Inspection Service of the Department of Agriculture and are not prohibited by the U.S. Fish and Wildlife Service. What about livestock and animals? Inspection and quarantine requirements of the Animal and Plant Health Inspection Service, or APHIS, must be met for the importation of A. All cloven-hoofed animals, ruminants, such as cattle, sheep, deer, antelope, camels, giraffes. B. Swine, including the various varieties of wild hogs and the meat from such animals. C. Horses, asses, mules, and zebras. D. All avian species, including poultry and pet birds. Animal byproducts, such as untanned hides, wool, hair, bones, bone meal, blood meal, animal casings, glands, organs, extracts, or secretions of ruminants and swine. If animal byproducts for food, drugs, or cosmetics, they are also regulated by the Food and Drug Administration. Animal germplasm, including embryos and semen, and G. Hay and straw. A permit for importation must be obtained from APHIS before shipping from the country of origin. In addition, all animal imports must be accompanied by a veterinary health certificate. Entry procedures for livestock and animals from Mexico and Canada are not as rigorous as those for animals from other countries. Entries of animals is restricted to certain ports that have been designated as quarantine stations. All non-domesticated animals must meet the requirements of the Fish and Wildlife Service. Meat and meat products are also subject to special requirements. All commercial shipments of meat and meat food products derived from cattle, sheep, swine, goats, and horses offered for entry into the United States are subject to the regulations of the Department of Agriculture and must be inspected by the Animal and Plant Health Inspection, APHIS, and the Food Safety and Inspection of that department prior to release by U.S. Customs. Meat products from other sources, including, but not limited to wild game, are subject to APHIS regulations, the provisions of the Federal Food, Drug, and Cosmetic Act, enforced by the Food and Drug Administration, and the U.S. Fish and Wildlife Service. Plant and plant products. The importation of plants and plant products is subject to regulations of the Department of Agriculture and may be restricted or prohibited. Plants and plant products include fruits, vegetables, plants, nursery stock, bulbs, roots, seeds, certain fibers including cotton and broomcorn, cut flowers, sugarcane, certain cereals, elm logs, and elm lumber with bark attached. Import permits are required. Further information should be obtained from APHIS. Also, certain species of plants may be prohibited or require permits or certificates. The Food and Drug Administration also regulates plant and plant products, particularly fruits and vegetables. Poultry and poultry products. Poultry, live, dressed, or canned eggs, including eggs for hatching, and egg products, are subject to the requirements and regulations of the Animal and Plant Health Inspection Service and the Food Safety and Inspection Service of the Department of Agriculture. Except for live poultry and poultry products entering through land ports from Canada, permits are required, as well as special marking and labeling, and in some cases, foreign inspection certification. The term poultry is defined as any live or slaughtered domesticated bird, such as chickens, turkeys, ducks, geese, swans, partridges, guinea fowl, peafowl, non-migratory ducks, pigeons, and doves. Other birds, such as commercial, domestic, or pen-raised grouse, pheasants and quail, and migratory birds, as well as certain egg products, are subject to APHIS regulations and to the provision of the Federal Food, Drug, and Cosmetic Act, enforced by the Food and Drug Administration. Inquiry should also be made to the Fish and Wildlife Service. Seeds. The importation into the United States of agricultural and vegetable seeds and screenings is governed by the provisions of the Federal Seed Act of 1939 and regulations of the Agricultural Marketing Service of the Department of Agriculture. Shipments of seeds will be detained pending the drawing and testing of samples. That concludes our discussion on the special requirements relating to agricultural commodities. Let's take a look at the special requirements related to arms, ammunition, explosives, and implements of war. These items are prohibited importation, except when a license is issued by the Bureau of Alcohol, Tobacco and Firearms of the Department of Treasury, or the importation is in compliance with the regulations of that department. The temporary importation, in-transit movement, and exportation of arms and ammunition, is prohibited unless a license is issued by the Office of Defense Trade Control's Department of State, or unless a license exemption is available as set forth in Title 22 CFR Section 123.4 and other sections of Title 22. Many radioisotopes, all forms of uranium, thorium, and plutonium, and all nuclear reactors imported into the United States are subject to the regulations of the Nuclear Regulatory Commission, or NRC, in addition to import regulations imposed by any other agency of the United States. Authority to import these commodities or articles containing these commodities requires a license from the Nuclear Regulatory Commission. Radioisotopes and radioactive sources intended for medical use are subject to the provisions of the Federal Food, Drug, and Cosmetic Act, enforced by the Food and Drug Administration. In order to comply with the Nuclear Regulatory Commission requirements, the importer must be aware of the identity and amount of any NRC-controlled radioisotopes, or uranium, thorium, and plutonium, and of any nuclear reactor being imported into the United States. To assure passage through customs, the importer must demonstrate to U.S. Customs which Nuclear Regulatory Commission authority the controlled commodity is being imported under. The authority cited may be the number of a specific or general license, or the specific section of the Nuclear Regulatory Commission regulations, which establishes a general license or grants an exemption to the regulations. The foreign exporter may save time for the prospective importer by furnishing the importer with complete information concerning the presence of NRC-controlled commodities in U.S. importation. Now, let's look at the special requirements relating to household appliances. The Energy Policy and Conservation Act calls for energy standards for certain major household appliances, and for labeling them to indicate expected energy consumption or efficiency. The Department of Energy, Office of Codes and Standards, is responsible for test procedures and energy performance standards. The Federal Trade Commission, Division of Enforcement, regulates the labeling of these appliances. The Act covers the following household appliance. 1. Refrigerators, freezers, and freezers. 2. Room air conditioners. 3. Central air conditions and central air conditioning heat pumps. 4. Water heaters. 5. Furnaces. 6. Dishwashers. 7. Clothes washers. 8. Clothes dryers. 9. Direct heating equipment. 10. Kitchen ranges and ovens. 11. Pool heaters, and 12. Fluorescent lamp ballasts. For commercial and industrial equipment. The Energy Policy Act of 1992, or EPACT, calls for energy performance standards for certain commercial and industrial equipment. The Department of Energy, Office of Codes and Standards, is responsible for test procedures and energy performance standards. The EPACT covers the following equipment. 1. Small and large commercial package air condition and heating equipment. 2. Package terminal air conditions and heat pumps. 3. Warm air furnaces. 4. Packaged boilers. 5. Storage water heaters. 6. Instantaneous water heaters. 7. Unfired hot water storage tanks. 8. Large electric motors, 1 to 200 horsepower, whether shipped separately or as a part of a large assembly. 9. 4-foot medium bi-pin, 2-foot U-shaped, 8-foot slimline, and 8-foot high-output fluorescent lamps, and 10. Incandescent reflector lamps. In addition, EPACT calls for water conservation standards for the following plumbing products. 1. Lavatory faucets. 2. Lavatory replacement aerators. 3. Kitchen faucets. 4. Kitchen replacement faucets. 5. Metering faucets. 6. Gravity tank type toilets. 7. Flushometer tank toilets. 8. electromechanical hydraulic toilets. 9. Blowout toilets, and 10. Urinals. Importation of these products must comply with the applicable Department of Energy and Federal Trade Commission requirements. Importers should contact these agencies for requirements which will be in effect at the time of the anticipated shipment. It should be noted that not all appliances are covered by requirements of both agencies. Any consumer product offered for importation will be refused admission if the product fails to comply with an applicable product safety standard or regulation, with a specified labeling or certification requirement, or is determined to present a substantial product hazard. These requirements are administered by the U.S. Consumer Product Safety Commission, or CPSC. Toys and other children's articles cannot be imported into the United States if they fail to comply with applicable regulations issued under the Federal Hazardous Substances Act. We'll discuss the major regulations dealing with toys here. Toys and other articles intended for children under 3 years of age cannot have small parts that present choking hazards to small children. The Child Safety Protection Act and its implementing regulations require warning labeling on toys for children who are at least 3 years old, but less than 6 years old, and that present choking hazards from small parts. These regulations also cover balloons, small balls for children under age 3 are banned, and marbles. Electric toys, rattles, pacifiers, and cribs are also subject to specific safety regulations. CPSC's regulations contain tests used to define hazardous sharp edges and points out on toys and other children's articles. Lawn darts are banned. Paint and other similar surface coating materials intended for consumer use are banned if they contain more than 0.06% lead. This ban also applies to furniture with paint that exceeds 0.06% lead, and to toys or other articles intended for use by children with paint that exceeds 0.06% lead. Such products cannot be admitted into the United States. Although this ban applies to surface coatings, CPSC can take action, under the Federal Hazardous Substances Act, against other lead-containing products, if the lead content results in a substantial risk of injury or illness. Bicycles cannot be admitted unless they meet regulations issued under the Federal Hazardous Substances Act. The CPSC also has mandatory safety standards for bicycle helmets. Bicycle helmets will not be admitted unless they meet CPSC's final safety standard for bicycle helmets. Bicycle helmets need to be accompanied by a certificate of compliance. As for fireworks, the fireworks regulations issued under the Federal Hazardous Substance Act set labeling requirements and technical specifications for consumer fireworks. Large fireworks, such as cherry bombs and M80s, are banned for consumer use. Large reloadable mortar shell fireworks are banned, and large multiple tube mine and shell fireworks are subject to specific requirements to prevent tip-over. Fireworks not meeting any of these requirements cannot be imported into the United States. As to flammable fabrics, any article of wearing apparel, fabric, or interior furnishings cannot be imported into the United States if it fails to conform to an applicable flammability standard issued under the Flammable Fabrics Act. These flammability standards over general wearing apparel, children's sleepwear, mattresses, including futons and carpets and rugs. Certain products can be imported into the United States, as provided in Section 11(c) of the Act, for the purpose of finishing or processing, to render such products not so highly flammable as to be dangerous when worn by individuals, provided that the exporter states on the invoice or other paper relating to the shipment that the shipment is being made for that purpose. Art materials cannot be imported into the United States unless they meet the labeling of Hazardous Art Materials Act, LAMA, of 1988, which is an amendment to the Federal Hazardous Substances Act. LAMA requires that chronically hazardous art materials carry the warning labeling specified in an industry standard, ASTM D4236. This standard also requires that art materials carry a label certifying that they have been reviewed by a toxicologist and identifying any known hazards. Other regulations and standards. CPSC has issued a number of other safety standards and regulations. These have generally been of less interest to the importing community because fewer of these items are imported. These include architectural glazing, matchbooks, CB and TV antennas, walk-behind power lawnmowers, swimming pool slides, cellulose insulation, garage door operators, unstable refuse bins, flammable contact adhesives, patching compounds with asbestos, emberizing materials with asbestos, household chemicals, refrigerator doors. Poison Prevention Packaging Act requires child-resistant packaging of certain drugs and household chemicals. Let's look at radiation-producing products, including sonic radiation. Television products that incorporate a cathode ray tube, cold cathode gas discharge tubes, microwave ovens, cabinet and diagnostic X-ray equipment, laser products, ultrasound physical therapy products, for which there are radiation performance standards, are subject to the Federal Food, Drug, and Cosmetic Act, Chapter 5, Subchapter C, Electronic Product Radiation. An electronic product, A, for which there is a radiation performance standard, and B, that is imported for sale or use in the United States, may be imported only if a declaration, Form FDA 2877, is filed with each importer's entry notice. The declaration must describe the compliance status of the product. The importer must affirm that the product 1. Not subject to a standard, such as manufactured prior to the effective date of the applicable federal standard, or 2. Complies with the standard and has a label affixed by the manufacturer certifying compliance, or 3. Does not comply with the standard but is being imported only for purposes of research, investigation, study, demonstration, or training, or 4. Does not now comply with the standard but will be brought into compliance. The provisions of the Federal Food, Drug, and Cosmetic Act, Chapter 5, Subchapter C, Electronic Product Radiation, apply to electronic products manufactured in the United States, as well as to imported products. Radios, tape recorders, stereos, televisions, citizen band radios or combination thereof, and other radio frequency devices, are subject to radio emission standards of the Federal Communications Commission. Importations of such products may be accompanied by an FCC declaration, FCC 740, certifying that the imported model or device is in conformity with, will be brought into conformity, or is exempt from the Federal Communication Commission requirements. Let's talk about the special requirements relating to importing food, drugs, cosmetics, and medical devices. The importation into the United States of food, drugs, devices, and cosmetics is governed by the provisions of the Federal Food, Drug, and Cosmetic Act, which is administered by the Food and Drug Administration of the Department of Health and Human Services. That act prohibits the importation of articles that are adulterated or misbranded, including products that are defective, unsafe, filthy, or produced under unsanitary conditions. The term misbranded includes statements, designs, or pictures in labeling that are false or misleading, or that fail to provide required information in labeling. The Act also prohibits the importation of pharmaceuticals that have not been approved by the FDA for admission into the United States. Imported products regulated by the Food and Drug Administration are subject to inspection at the time of entry. Shipments found not to comply with the laws and regulations are subject to refusal. They must be brought into compliance if it is possible to do so. Any sorting, reprocessing, or relabeling must be supervised by the Food and Drug Administration at the importer's expense. Various inspected foods such as confectionery, dairy products, poultry, eggs and egg products, meats, fruits, nuts, and vegetables are also subject to requirements of other agencies. Certain aquatic species may also be subject to the requirements of the National Marine Fisheries Service of the National Oceanic and Atmosphere Administration of the Department of Commerce. For biological drugs, the manufacture and importation of biological products for human consumption are regulated under the Public Health Service Act. Domestic and foreign manufacturers of such products must obtain a U.S. license for both the manufacturing establishment and the product intended to be produced or imported. Additional information may be obtained from the Food and Drug Administration. Biological drugs for animals are regulated under the Virus Serum Toxin Act, which is administered by the Department of Agriculture. The importation of viruses, serums, toxins, and analogous products, and organisms and vectors for use in the treatment of domestic animals is prohibited unless the importer holds a permit from the Department of Agriculture covering the specific product. These importations are also subject to special labeling requirements. For biological materials and vectors, the importation into the United States for sale, barter, or exchange for any virus, therapeutic serum, toxin, antitoxin, or analogous products, or arsphenamine or its derivatives, or any other trivalent organic arsenic compound, except materials to be used in research experiments applicable to the prevention, treatment, or cure of diseases or injuries of man, is prohibited, unless these products have been propagated or prepared at any establishment holding an unsuspended and unrevoked U.S. license for such manufacturing, issued by the Secretary of the Department of Health and Human Services. Samples of the U.S. licensed product must be accompanied each importation for forwarding by the Port Director of Customs at the port of entry to the Director of the Center for Biologics Evaluation and Research. A permit from the U.S. Public Health Service, Centers for Disease Control and Prevention, is required for shipments of any etiological agent or insect, animal or plant vector of human disease, or any exotic living insect, animal, or plant capable of being a vector of human disease. For narcotic drugs and derivatives, the importation of controlled substances, include narcotic, marijuana, and other dangerous drugs, is prohibited, except when imported in compliance with regulations of the Drug Enforcement Administration of the Department of Justice. Examples of some of the prohibited controlled substances are amphetamines, barbiturates, coca leaves and derivatives, such as cocaine, hallucinogenic substances such as LSD, mescaline, peyote, marijuana, and other forms of cannabis, opiates, including methadone, opium, including opium derivatives, such as morphine and heroin, synthetic substitutes for narcotic drugs, and anabolic steroids. For drug paraphernalia, items of drug paraphernalia are prohibited from importation or exportation under Section 863, Title 21 of the United States Code. The term drug paraphernalia means any equipment, product, or material of any kind which is primarily intended or designated for use in manufacturing, compounding, converting, concealing, producing, processing, preparing, injecting, ingesting, inhaling, or otherwise introducing into the human body a controlled substance, possession of which is unlawful under the Controlled Substance Act. Items of drug paraphernalia include, but are not limited to, the following items. 1. Metal, wooden, acrylic, glass, stone, plastic, or ceramic pipes with or without screens, permanent screens, hashish heads, or punctured metal bowls. 2. Water pipes. 3. Carburation tubes and devices. 4. Smoking and carburation masks. 5. Roach clips, meaning objects used to hold burning material, such as a marijuana cigarettes that has become too small or too short to be held in the hand. 6. Miniature spoons with level capacities of 1/10 cubic centimeter or less. 7. Chamber pipes. 8. Carburetor pipes. 9. Electric pipes. 10. Air-driven pipes. 11. Chillums. 12. Bongs. 13. Ice pipes or chillers. 14. Wired cigarette papers, or 15. Cocaine freebase kits. Now, let's talk about the special requirements related to importing gold, silver, currency, and stamps. Gold and silver. The provisions of the National Stamping Act are enforced by U.S. Customs and by the FBI. Articles made of gold or alloys thereof are prohibited importation into the United States if the gold content is 3/1000th parts below the indicated fineness. In the case of articles made of gold or gold alloy, including the solder and alloy of inferior fineness, 3/1000th parts below the indicated fineness is permitted. Articles marked sterling or sterling silver must assay at least 0.925% of pure silver, with a 0.004 divergence allowed. Other articles of silver or silver alloys must assay not less than 0.004 part below the indicated fitness thereof. Articles marked coin or coin silver must contain at least 0.900 part pure silver, with an allowable divergence of 0.004 part below. A person placing articles of gold or silver bearing a fineness or quality mark such as 14K, sterling, etc., in the mail or in interstate commerce must place his name or registered trademark next to the fineness mark in letters the same size as the fineness mark. The trademark or name is not required at the time of importation, therefore, Customs has no direct responsibility for enforcement of the law. Persons making inquiry or seeking advice or interpretation of the law should consult the Department of Justice. Articles bearing the words United States assay are prohibited importations. Articles made wholly or in part of inferior metal and plated or filled with gold or silver or alloys thereof, and which are marked with the degree of fineness, must also be marked to indicate the plated or filled content, and in such cases, the use of the word sterling or coin is prohibited. All restrictions on the purchase, holding, selling, or otherwise dealing with gold were removed effective December 31, 1974, and gold may be imported subject to the usual customs entry requirements. Under the Hobby Protection Act, administered by the Bureau of Consumer Protection of the Federal Trade Commission, any imitation numismatic item must be plainly and permanently marked copy. Those that do not comply are subject to seizure and forfeiture. Unofficial gold coin restrikes must be marked with the country of origin. It is advisable to obtain a copy of the legal proclamation under which the coins are issued, or else an affidavit of government sanctions of coins should be secured from a responsible banking official if the proclamation is unavailable. Counterfeit articles. Articles bearing facsimiles or replicas of coins or securities of the United States or of any foreign country cannot be imported. Counterfeits of coins in circulation in the United States, counterfeited, forged, or altered obligations or other securities of the United States or of any foreign government, plates, dies, or other apparatus which may be used in making any of the foregoing, are prohibited importations. Under the Currency and Foreign Transactions Reporting Act, if a person knowingly transports, is about to transport, or has transported, more than $10,000 in monetary instruments at one time to, through, or from, the United States, or if a person receives more than $10,000 at one time from or through a place outside the United States, a report of the transportation, Customs Form 4790, must be filed with the U.S. Customs Service. Monetary instruments include U.S. or foreign coin, currency, traveler's checks in any form, personal and other checks, and money orders, either in bearer negotiable form or endorsed without restriction, and securities or stocks in bearer form. A bank check or money order made payable to a named person, but not endorsed, or which bears a restrictive endorsement, is not considered to be a monetary instrument. The Department of the Treasury regulate the report of monetary instruments. Let's talk about the special requirements pertaining to pesticides, toxic and hazardous substances. For pesticides, the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA, provides the statutory authority governing the importation of pesticides and devices into the United States. Promulgated under Section 17(c) of this authority, the U.S. Customs Service regulations at Title 19, CFR, Parts 12.112 through 12.117 describe the procedures governing the importation of pesticides and devices. Among the requirements described in these regulations, importers must submit a notice of arrival that has been submitted for review and approved by the EPA prior to the importation. Pesticides must be registered in accordance with FIFRA, Section 3, or they will be refused entry into the United States. Devices are not subject to product registration, but the labeling of both pesticides and devices must bear the producer establishment's number registered with the EPA. In addition, pesticides and devices will be refused entry if they are identified as adulterated or misbranded, if they in any other way violate the provisions of FIFRA, or if they are otherwise injurious to health or environment. As to toxin substances, the Toxin Substances Control Act, or TSCA, regulates the manufacturing, importation, processing, distribution and commerce, use or disposal of any chemical substances or mixtures that are broadly defined in Section 3 of the TSCA. Section 3 specifies that certain substances are excluded from the definition of chemical substance based upon their use. These substances include, but are not limited to, foods, drugs, cosmetics, and active ingredients in pesticides. Importations will not be released from customs custody unless proper certification is presented to customs that the import complies with, or is not subject to the requirements of the Toxin Substances Control Act, or if it is already identified as a food, drug, or active pesticide ingredient. For hazardous substances, the importation into the United States of dangerous caustic or corrosive substances in packages suitable for household use and of hazardous substances is regulated by the Hazardous Substance Act, the Caustic Poison Act, the Food, Drug, and Cosmetic Act, and the Consumer Product Safety Act. The marking, labeling, packaging, and transportation of hazardous materials, substances, wastes, and their containers is regulated by the Office of Hazardous Materials Transportation of the Department of Transportation. Hazardous waste is a special subcategory of hazardous substances and is regulated by the Resource Recovery and Conservation Act, which requires a special EPA manifest for both imports and exports. Now, let's go over the special requirements for textile, wool, and fur products. For textile products, all textile fiber products imported into the United States shall be stamped, tagged, labeled, or otherwise marked with the following information, as required by the Textile Fiber Products Identification Act, unless exempted from marking, under Section 12 of the Act. 1. The generic names and percentages by weight of the constituent fibers present in the textile fiber product, exclusive of permissive ornamentation, in amounts of more than 5%, in order of predominance by weight, with any percentage of fiber or fibers required to be designated as other fiber or other fibers appearing last. Fibers present in amounts of 5% or less must be designated as other fibers. 2. The name of the manufacturer, or the name or registered identification number issued by the Federal Trade Commission, of one or more persons marketing or handling the textile fiber product. A word trademark, used as a house mark, registered in the United States Patent Office, may be used on labels, in lieu of the name otherwise required, if the owner of such trademark furnishes a copy of the registration to the Federal Trade Commission prior to use. 3. The name of the country where processed or manufactured. In order to enforce the Textile Fiber Products Identification Act, a commercial invoice covering a shipment of textile fiber products, exceeding $500 in value, is subject to the labeling requirements of the Act. In addition to labeling requirements, the importation of textiles and textile products may, pursuant to Section 204 of the Agricultural Act of 1956, be subject to quota, visa or export license requirements and additional entry requirements, including declarations identifying the fabricated components. 4. Wool. Any product containing woolen fiber imported into the United States, with the exception of carpet, rugs, mats, upholsteries, and articles made more than 20 years prior to importation, shall be tagged, labeled, or otherwise clearly marked with the following information, as required by the Wool Products Labeling Act of 1939. 1. The percentage of the total fiber weight of the wool product, exclusive of ornamentation, not exceeding 5% of the total fiber weight of A. Wool. B. Recycled wool. C. Each fiber other than wool if the percent by weight of such fiber is 5% or more, and D. The aggregate of all other fibers. 2. The maximum percent of the total weight of the wool product, of any non-fibrous loading, filing, or adulterating matter. 3. The name of the manufacturer or person introducing the product into commerce in the United States, that is, the importer. If the importer has a registered identification number issued by the Federal Trade Commission, that number may be used instead of the individual's name. For the purpose of enforcing the Wool Products Labeling Act, a commercial invoice covering a shipment of wool products exceeding $500 in value and subject to the labeling requirements of the Act is required. The provisions of the Wool Products Labeling Act and the regulations may be obtained from the Federal Trade Commission. 4. Fur. Any article of wearing apparel imported into the United States and made in whole or in part of fur or used fur, with the exception of articles made of new fur, of which the cost or manufacturer's selling price does not exceed $7, shall be tagged, labeled, or otherwise clearly marked to show the following the information, as required by the Fur Products Labeling Act. 1. The name of the manufacturer or person introducing the product into commerce in the United States, that is, the importer. If the importer has a registered identification number, that number may be used instead of the individual's name. 2. The name or names of the animal or animals that produced the fur, as set forth in the Fur Products Name Guide, as determined under the rules and regulations. 3. That the fur product contains used or damaged fur, where such is the fact. 4. That the fur product is bleached, dyed, or otherwise artificially colored, when such is the fact. 5. That the fur product is composed in whole or in substantial part of paws, tails, bellies, or waist fur, when such is the fact. 6. The name of the country of origin of any imported fur contained in a fur product. For the purpose of enforcing the Fur Products Labeling Act, a commercial invoice covering a shipment of furs or fur products exceeding $500 in value is required. Dog or cat fur. The importation, exportation, transportation, distribution, or sale of any product that consists or is composed in whole or in part of any dog fur, cat fur, or both, is prohibited. Any such product that is imported, exported, transported, distributed, or sold will be seized and forfeited, and penalties may be imposed against any person who violates this law. In addition, anyone found to have violated this prohibition may be barred from importing or exporting any fur product. This prohibition does not apply to the importation, exportation, or transportation, for non-commercial purposes, of personal pets that are deceased, including a pet preserved through taxidermy. The provisions of the Fur Products Labeling Act apply to fur and fur products in the United States, as well as to imported furs and fur products. Now, let's talk about the special requirements related to trademarks, trade names, and copyrights. Let's start with trademarks and trade names. Articles bearing counterfeit trademarks are subject to seizure and forfeiture. A counterfeit trademark is defined as a spurious trademark that is identical with, or substantially indistinguishable from, a registered trademark. Marks that copy or simulate a registered trademark that has been recorded with customs are subject to detention and possible seizure and forfeiture. The importation of parallel or gray market goods is restricted where the registered trademark has been recorded with customs and gray market protection has been afforded. In such instances, gray market merchandise is subject to detention and possible seizure and forfeiture. The U.S. Customs Service also affords similar protection against unauthorized shipments bearing trade names that are recorded with customs pursuant to regulations. A personal exemption for merchandise bearing an infringing mark is provided articles accompanying any person arriving in the United States when such articles are for his or her personal use and not for sale. Only one infringing item of each type bearing a registered trademark is permitted. An individual may take advantage of this exemption only once within a 30-day period. For copyrights, articles imported into the United States that are piratical of a registered copyright are subject to seizure and forfeiture. Now, let's talk about the special requirements related to wildlife and pets. For wildlife and pets, the importation of live wildlife, i.e., game animals, birds, plants, or any part or product made therefrom, and of birds' eggs, is subject to certain prohibitions, restrictions, permits, and quarantine requirements of several government agencies. Imports or exports of wildlife, their parts or products, must be declared at designated ports of the U.S. Fish and Wildlife Service, unless an exception is granted prior to the time of import or export. The Assistant Regional Director of Law Enforcement for the region in which the import or export will take place should be contacted for additional information or to request an exception to designated port permit. Any commercial importer or exporter, with some exceptions, importing or exporting wildlife, must obtain a license from the Fish and Wildlife Service. Applications and further information may be obtained from the Fish and Wildlife Service, Assistant Regional Director Law Enforcement for the region in which the importer or exporter is located. Endangered species of wildlife and certain species of animals and birds are generally prohibited entry into the United States and may be imported or exported only under a permit granted by the U.S. Fish and Wildlife Service. Antiques articles, at least 100 years old, may be exempt from certain requirements of the U.S. Endangered Species Act. The taking and importation of marine mammals and their products are subject to the requirements of the Marine Mammal Protection Act, or MMPA, of 1972. The National Marine Fisheries Service, or NMFS, and the Fish and Wildlife Service have jurisdiction under the MMPA for certain species and import activities. Additional requirements of the U.S. Endangered Species Act and the Convention on International Trade in Endangered Species, or CITES, may apply. Prior to importing, both agencies should be contacted to learn the exact import requirements. Other NMFS import requirements also apply for certain species covered by the International Commission for the Conservation of Atlantic Tunas, such as Atlantic bluefin tuna. Certain mammals, birds, reptiles, amphibians, fish, snails, clams, insects, crustaceans, mollusks, other invertebrates, and plants may be prohibited entry without the prior issuance of a permit, either from the Foreign Wildlife Authority or from the Fish and Wildlife Service, Office of Management Authority. The importation into the United States of any wildlife, their parts or products, is prohibited if the wildlife was captured, taken, shipped, or possessed contrary to the laws of the foreign country. The importation of feathers or skins of any bird, except for scientific and educational purposes, is prohibited, with some exceptions. This prohibition does not apply to fully manufactured artificial flies, used for fishing, or to personally taken non-commercial game birds. Feathers or skins of the following species are permitted entry: chickens, turkeys, guinea fowl, geese, ducks, pigeons, ostriches, rheas, English ring-necked pheasants, and peafowl not taken from the wild. The Wild Bird Conservation Act became effective in October 1992. This act focuses on live bird species. If you import live birds, you must meet the requirements of this law, in addition to existing requirements of CITES, the Endangered Species Act, the Migratory Bird Treaty Act, or other applicable regulations. Import permits must be obtained from the Fish and Wildlife Service, Office of Management Authority. Live birds, their parts and products that are protected under the Migratory Bird Treaty Act, may be imported into the United States, for scientific purposes, or certain propagating purposes, only under permits, issued by the Fish and Wildlife Service, Office of Migratory Birds, located in the region where the importation will occur, or where the importer resides. Imports of birds, pets, migratory birds, falcons, are subject to the quarantine requirements of the USDA and Public Health Service. Quarantine space must be reserved in advance of import. Prior to export, health certificates must be obtained. On June 9, 1989, the U.S. Fish and Wildlife Service announced a ban on the importation of most African elephant ivory and any products made from it. The ban covers all commercial and non-commercial shipments, including personal baggage accompanying a tourist. There are limited exceptions for antiques, trophies, and personal household effects. The importation of birds, cats, dogs, monkeys, and turtles is subject to the requirements of the U.S. Public Health Service, Centers of Disease Control Quarantine Division, of the Veterinary Services of the Animal and Plant Health Inspection Service, Department of Agriculture, and of the U.S. Fish and Wildlife Service. The importation of live turtles, tortoises, and terrapins with a carapace length of less than 4 inches, and the viable eggs of turtles, tortoises, and terrapins, is allowed by the U.S. Public Health Service, only under strict requirements as to purpose and quantity. The U.S. Public Health Service does not allow the importation of live, non-human primates, including monkeys, as pets. Now, we'll talk about the special requirements pertaining to other miscellaneous prohibited or restricted merchandise. White or yellow phosphorus matches, fireworks banned under federal or state restrictions, pepper shells, switchblade knives, and lottery tickets are prohibited. For foreign assets control restrictions. The Office of Foreign Assets Control administers regulations which generally prohibit the importation of merchandise or goods that contain components from the following countries: Taliban, Afghanistan, Cuba, Iran, Iraq, Libya, Serbia, and Sudan. These restrictions apply to the country of origin, regardless of where the item was acquired. These proscriptions do not apply to informational materials, such as pamphlets, books, tapes, films, or recordings, except those from Iraq. There are also strong restrictions on the importation of rough diamonds from Sierra Leone, Angola, and Liberia. Contact your local port for more information on these so-called conflict diamonds. Specific licenses are required to bring prohibited merchandise into the United States, but they are rarely granted. Foreign visitors to the United States, however, may usually be permitted to bring in small articles for personal use as accompanied baggage, depending upon the goods' country of origin. Travelers should be aware of certain travel restrictions that may apply to these countries. Because of the strict enforcement of these prohibitions, those anticipating foreign travel to any of the countries we just mentioned would do well to write in advance to the Office of Foreign Assets Control, Department of Treasury. As to obscene, immoral, seditious matter and lottery tickets. Section 305 of the Tariff Act of 1930 prohibits the importation of any book, writing, advertisement, circular, or picture containing any matter advocating or urging treason or insurrection against the United States, or forcibly resistance to any law of the United States, or contain any threat to take the life or inflict bodily harm upon any person in the United States, or any obscene book, writing, advertisement, circular, picture, or other representation, figure, or image, on or of paper or other material or any instrument or other article which is obscene or immoral, or any drug or medicine for causing unlawful abortion, unless otherwise authorized by law, such as FDA approved, or any lottery ticket, except if printed in Canada for use in a U.S. or in some cases, other foreign lottery. For petroleum and petroleum products. Importation of petroleum and petroleum products are subject to the requirements of the Department of Energy. An import license is no longer required, but an import authorization may be needed. These importations may be subject to an oil import license fee, collected and administered by the Department of Energy. Inquiries should be directed to the Department of Energy. For products of convict or forced labor. Merchandise produced, mined, or manufactured, wholly or in part, by means of the use of convict labor, forced labor, or indentured labor under penal sanctions, is prohibited from importation, provided a finding has been published, pursuant to Section 12.42 of the Customs Regulations, that certain classes of merchandise from a particular country, produced by convict, forced, or indentured labor, were either being, or are likely to be, imported into the United States in violation of Section 307 of the Tariff Act of 1930. For unfair competition. Section 337 of the Tariff Act of 1930 prohibits the importation of merchandise if the President finds that unfair methods of competition or unfair acts exist. This section is most commonly invoked in the case of patent violations. Although a patent need to be at issue, prohibition of entries of the merchandise in question generally is for the term of the patent, although a different term may be specified. Following a Section 337 investigation, the International Trade Commission may find that unfair methods of competition or unfair acts exist with respect to the importation of certain merchandise. After the International Trade Commission has issued an order, the President is allowed 60 days to take action to communicate his approval or disapproval of such determination. Should the 60 days expire without presidential action, the order becomes final. During the 60-day period, or until the President acts, importation of the merchandise is allowed under a special bond, but it must be recalled by customs, if appropriate, under the conditions of the order, when it becomes final. If the President determines that entry of the merchandise is not in violation of Section 337, the bond is cancelled. Importation of articles bearing the title, abbreviations, initials, symbols, emblems, seals, or badges of any subdivision of the Department of Treasury, or likeness thereof, are prohibited, unless the subdivision has authorized the use of the symbol, initials, etc. For artifacts or cultural property. A number of U.S. laws are applicable to importations of artifacts, such as archaeological and ethnological objects. For example, U.S. law prohibits the importation of pre-Columbian monumental and architectural sculpture and murals from countries in Central and South America without proper export permits from the country of origin. U.S. Customs will not accept an export permit from a third country. Also, importations of certain archaeological and ethnographic material from El Salvador, Guatemala, Peru, Mali, and Canada are specifically restricted from entering the United States, unless they are accompanied by an export certificate issued by the country of origin. These restrictions are aimed at deterring the pillage of other countries' cultural heritage and at fostering opportunities for access to cultural objects for legitimate scientific, cultural, and educational purposes. Federal law also prohibits the importation of any article of cultural property stolen from museum or from religious or secular public monuments. Importers should be aware that a treaty exists between the United States and Mexico on cultural property recovery. Would-be buyers of such property should be aware that, unlike purchases of customary tourist merchandise, purchases of cultural objects do not confer ownership, should the object be found to be stolen. The U.S. National Stolen Property Act may be applicable in such cases, particularly if a country of origin declares by law that it owns the cultural objects, known or unknown, within its present-day political boundaries. Purveyors of such merchandise have been known to offer fake export certificates. Prospective buyers should be aware that customs inspectors are expert at spotting fraudulent export certificates that accompany cultural property. Customs inspectors will also examine declaration forms to determine whether any false information has been entered, since this also constitutes a violation. As to United States trade representative actions, as authorized by the Trade Act of 1974, the United States Trade Representative, or USTR, administers Section 301 complaints against foreign unfair trade practices that harm U.S. exporters. USTR actions that may directly affect U.S. importers include the suspension of concessions. For example, the USTR may suspend the normal trade relations rate of duty and substitute a substantially higher rate of duty on designated products from a foreign country that is found to be discriminating against U.S. products. The International Trade Administration, at the Department of Commerce, has set up a notification system that will advise importers of USTR actions that may affect imported products. Importers should be advised that once the USTR has taken a Section 301 action, U.S. Customs is responsible for implementing the action as directed by USTR. Let's talk about the special requirements pertaining to importing alcoholic beverages. Any person or firm wishing to engage in the business of importing distilled spirits, wines, or malt beverages into the United States must first obtain an importer's basic permit from the Bureau of Alcohol, Tobacco and Firearms of Department of Treasury. That agency is responsible for administering the Federal Alcohol Administration Act. Distilled spirits imported in bulk containers, of a capacity of more than 1 gallon, may be withdrawn from customs custody only by person to whom it is lawful to sell or otherwise dispose of distilled spirits in bulk. Bulk or bottled shipments of imported spirits or distilled or intoxicating liquors must, at the time of importation, be accompanied by a copy of a bill of lading or other documents, such as an invoice, showing the name of the consignee, the nature of its contents, and the quantity contained therein. U.S. Customs will not release alcoholic beverages destined to any state for use in violation of its laws, and the importation of alcoholic beverages in the mails is prohibited. The United States adopted the metric system of measurement with the enactment of the Metric Conversion Act of 1975. In general, imported wine must conform to the metric standards of fill, if bottled or packed, on or after January 1, 1979. Imported distilled spirits, with some exceptions, must conform with the metric standards of fill, if bottled or packed, on or after January 1, 1980. Distilled spirits and wines bottled or packed prior to the respective dates must be accompanied by a statement to that effect, signed by a duly authorized official of the appropriate foreign country. This statement may be a separate document or may be shown on the invoice. Malt beverages, including beer, are not subject to metric standards of fill. For marking requirements, Imported wines in bottles and other containers are required to be packaged, marked, branded, and labeled in accordance with the regulations in Title 27 CFR, Part 4. Imported malt beverages, including alcohol-free and non-alcoholic malt beverages, are also required to be labeled in conformance with the regulations in Title 27 CFR, Part 7. The labeling regulations governing imported distilled spirits can be found in Title 27 CFR, Part 5. Each bottle, cask or other immediate container of imported distilled spirits, wines, or malt beverages must be marked for customs purposes to indicate the country of origin of the alcoholic beverage contained therein, unless the shipment comes within one of the exceptions. As to certificate of label approval, labels affixed to bottles of imported distilled spirits, wine, and malt beverages must be covered by certificates of label approval issued to the importer by the Bureau of Alcohol, Tobacco, and Firearms. Certificates of label approval or photostatic copies must be filed with customs before the goods may be released for sale in the United States. Certificate of label approval requirements must also be met for fermented malt beverages, if similar to the federal requirements. Importers of wines and distilled spirits should consult the Bureau of Alcohol, Tobacco, and Firearms about foreign documentation required, for example, certificates of origin, age, etc. Wines or distilled spirits from certain countries require original certificates of origin as a condition of entry. As to the requirements of other agencies, in addition, the importation of alcoholic beverages is subject to the specific requirements of the Food and Drug Administration. Certain plant materials, when used for bottle jackets for wine or other liquids, are subject to special restrictions under plant quarantine regulations of the Animal and Plant Health Inspection Service. All bottle jackets made of dried or unmanufactured plant materials are subject to an inspection upon arrival and are referred to the Department of Agriculture. Federal law also requires a health warning to appear on the labels of containers of alcoholic beverages bottled on or after November 18, 1989. The warning must state: Government warning. 1. According to the Surgeon General, women should not drink alcoholic beverages during pregnancy because of the risk of birth defects. 2. Consumption of alcoholic beverages impairs your ability to drive a car or operate machinery and may cause health problems. Now, let's turn our attention to the special requirements pertaining to motor vehicles and boats. For automobiles, vehicles, and vehicle equipment. Safety, bumper, and emission requirements. As a general rule, all imported motor vehicles less than 25 years old and items of motor vehicle equipment must comply with all applicable federal motor vehicle safety standards in effect when these vehicles or items were manufactured. A customs inspection at the time of entry will determine such compliance, which is verified by the original manufacturer's certification permanently affixed to the vehicle or merchandise. An entry declaration form, HS7, must be filed when motor vehicles or items of motor vehicle equipment are entered. The HS7 can be obtained from customs brokers or ports of entry. Certain temporary importations may be exempt from the requirements for conformance if written approval is obtained in advance from both the U.S. Department of Transportation and the Environmental Protection Agency. This includes vehicles brought in for research, demonstrations, investigation, studies, testing, or competitive events. Also, EPA Form 3520-1 and DOT Form HS7 must be submitted to customs at the time of entry as made for such vehicles. Vehicles imported for temporary use by certain non-residents or by members of foreign governments or foreign armed forces may not be required to comply with safety, bumper, emission, or theft prevention standards. Non-conforming vehicles imported by non-residents for personal use must be exported at the end of 1 year. Vehicles described here may also require EPA and DOT declarations. A DOT bond in the amount of 150% of the vehicle's dutiable value must be posted at the port of entry when a non-certified or non-conforming vehicle is imported for permanent use. The importer must also sign a contract with a DOT-registered importer who will modify the vehicle to conform with all applicable safety and bumper standards, and who can certify the modifications. A copy of this contract must be furnished to the Customs Service with the HS7 at the port of entry. Furthermore, the vehicle model and model year must be determined to be eligible for importation. The Clean Air Act prohibits the importation of any motor vehicle or motor vehicle engine not in conformity with emission requirements prescribed by the U.S. Environmental Protection Agency, EPA. This restriction applies whether the motor vehicle or motor vehicle engine is new or used, and whether it was originally produced for sale and use in a foreign country, or originally produced or later modified to conform to EPA requirements for sale or use in the United States. In addition to passenger cars, all trucks, multipurpose vehicles, such as all-terrain vehicles, campers, motorcycles, etc., that are capable of being registered by a state for use on public roads, or that the EPA has deemed capable of being safely driven on public roads, are subject to these requirements. The term vehicle is used to include all EPA-regulated vehicles and engines. For non-road engine imports, in accordance with the Clean Air Act and implementing regulations, the EPA began regulating certain non-road diesel and gasoline engines, requiring that they meet federal emission standards beginning January 1, 1996. Non-road, also referred to as off-road or off-highway, is a term that covers a diverse group of engines and equipment. The non-road category includes lawn and garden equipment, outdoor power equipment, recreational equipment, farm equipment, construction equipment, marine engines, and locomotives. Prior to importation into the United States, regulated non-road engines must be covered by an EPA-issued certificate of conformity. The certificate is issued by EPA to the engine manufacturer, which declares that the engine family named on the certificate conforms with all applicable emission standards and other requirements. It also permits the manufacturer to sell, offer for sale, introduce into commerce, or import into the United States the named engine family. Certificates are issued for only one model year at a time. A label confirming that the engine meets emission standards must be affixed to the engine and readily visible. Upon request, an importer must provide an EPA Form 3520-21 to Customs at the time of entry into the United States. This form must contain the following information about the engine: model, model number, serial number, horsepower, build date, and manufacturer. It must also include a description of the equipment or vehicle containing the engine, including the equipment manufacturer, equipment serial number, and the location of the EPA emissions label and engine serial number. For U.S. version vehicles, any person may import U.S. version vehicles. All such 1971 and later models are required to have a label in a readily visible position in the engine compartment, stating that the vehicle conforms to the U.S. requirements. This label will read vehicle emission control information and will have a statement by the manufacturer that the vehicle meets U.S. EPA emission requirements at the time of manufacture. If this label is not present, the importer should obtain a letter of conformity from the manufacturer's United States representative, not from a dealership, prior to importation. As to non-U.S. version vehicles, individuals are not permitted to import non-U.S. version vehicles unless otherwise excluded or exempted. These vehicles must be imported or entered by an independent commercial importer, or ICI, having a currently valid qualifying certificate of conformity for each vehicle being imported. The ICI will be responsible for performing all necessary modifications, testing and labeling, as well as providing an emissions warranty, identical to the emissions warranty required for new vehicles sold in the U.S. Vehicles at least 21 years old are exempt from these provisions, and may be imported without modification. Words of caution. 1. Not all non-conforming vehicles are eligible for importation, and ICIs are not required to accept vehicles for which they have qualifying certificates of conformity. 2. EPA certificates of ICIs does not guarantee the actions or work of the ICIs, nor does it regulate contractual agreements and working relationships with vehicle owners. 3. EPA strongly recommends that prospective importers buy only U.S version, labeled, vehicles, because of the expense and potential difficulties involved with importing a non-U.S. version vehicle. 4. EPA strongly recommends that current owners of non-U.S. version vehicles sell or otherwise dispose of them overseas, rather than ship and import them into the U.S., because of the expense and potential difficulty involved with importing a non-U.S. version vehicle. 5. Before shipping a non-conforming vehicle for importation, EPA strongly recommends that the importer either make final arrangements with an ICI for modifications and testing or obtain EPA approval in writing for importation. Storage fees at the ports are costly, and the vehicle may not be eligible for importation. 6. The EPA policy that permitted importers a one-time exemption for vehicles at least 5 years old has been eliminated. 7. EPA considers a U.S. version vehicle that has had modifications to its drivetrain or emission control system to be a non-U.S. version vehicle, even though it may be labeled a U.S. version vehicle. 8. Modifications necessary to bring a non-conforming vehicle into conformity with the safety, bumper, or emission standard may require extensive engineering, be impractical or impossible, or the labor and materials may be unduly expensive. It is highly recommended that these modifications be investigated before a vehicle is purchased for importation. For boat safety standards. Imported boats and associated equipment are subject to U.S. Coast Guard safety regulations or standards under the Federal Boat Safety Act of 1971. Products subject to standards must have a compliance certification label affixed to them. Certain hulls also require a hull identification number to be affixed. A U.S. Coast Guard import declaration is required to be filed with entries of non-conforming boats. Further information may be obtained from the Commandant, U.S. Coast Guard. Vessels brought into the United States for use in trade or commerce are not dutiable. Yachts or pleasure boats brought into the U.S. by non-residents for their own use in pleasure cruising are also not dutiable. Yachts or pleasure boats owned by a resident or brought into the United States for sale or chartered to a resident are dutiable. Vessels that are foreign-built or of foreign registry may be used in the United States for pleasure purposes and in the foreign trade of the U.S. However, federal law prohibits the use of such vessels in the coastwise trade, that is, the transportation of passengers or merchandise between points in the United States, including carrying fishing parties for hire. Now, let's talk about import quota and how that may affect imports. An import quota is a quantity control on imported merchandise for a certain period of time. Quotas are established by legislation, by directives, and by proclamation, issued under the authority contained in specific legislation. The majority of import quotas are administered by the U.S. Customs Service. The Commissioner of Customs controls the importation of quota merchandise, but has no authority to change or modify any quota. United States import quotas may be divided into two types: absolute and tariff rate. Under the NAFTA, there are tariff preference levels, which are administered like tariff rate quotas. Tariff rate quotas provide for the entry for a specified quantity of the quota product at a reduced rate of duty during a given period. There is no limitation on the amount of the product that may be entered during the quota period, but quantities entered in excess of the quota for the period are subject to higher duty rates. In most cases, products of communist-controlled areas are not entitled to the benefits of tariff rate quotas. Absolute quotas are quantitative, that is, no more than the amount specified, may be permitted entry during a quota period. Some absolute quotas are global, while others are allocated to specified foreign countries. Imports in excess of a specified quota may be held for the opening of the next quota period by placing it in a foreign trade zone, or by entering it for warehouse, or it may be exported or destroyed under customs supervision. The usual customs procedures generally applicable to other imports apply with respect to commodities subject to quota limitations. The quota status of a commodity subject to a tariff rate quota cannot be determined in advance of its entry. The quota rates of duty are ordinarily assessed on such commodities entered from the beginning of the quota period until such time in the period as it is determined that imports are nearing the quota level. Port directors of customs are then instructed to require the deposit of estimated duties at the over-quota duty rate and to report the time of official presentation of each entry. A final determination is then made of the date and time when a quota is filled, and all port directors are advised accordingly. Some of the absolute quotas are invariably filled at or shortly after the opening of the quota period. Each of these quotas is therefore officially opened at noon Eastern Standard Time, or the equivalent in other time zones, on the designated effective date. When the total quantity for these entries filed at the opening of the quota period exceeds the quota, the merchandise is released on a pro rata basis, the pro rata being the ratio between the quota quantity and the total quantity offered for entry. This assures that an equitable distribution of the quota. Merchandise is not regarded as presented for purposes of determining quota priority until an entry summary or withdrawal from warehouse for consumption has been submitted in proper form and the merchandise is located within the port limits. Information related to quotas can be obtained from the quota staff at U.S. Customs Service. For textile articles, the U.S. Customs Service administers import controls on certain cotton, wool, man-made fiber, silk blend, and other vegetable fiber articles manufactured or produced in designated countries. The U.S. Customs Service administers the Special Access Program and the Andean Trade Preference Act on certain products which are made of U.S. formed uncut fabric. These controls are imposed on the basis of directives issued to the Commissioner of Customs by the Chairman of the Committee for the Implementation of Textile Agreements. Information concerning specific import controls may be obtained from the Commission of Customs. Other information concerning the textile program may be obtained from the Chairman, Committee for the Implementation of Textile Agreements, U.S. Department of Commerce. For textile visa and export license requirements. A textile visa is an endorsement in the form of a stamp on an invoice or export control license that is executed by a foreign government. It is used to control the exportation of textiles and textile products to the United States and to prohibit the unauthorized entry of the merchandise into this country. A visa may cover either quota or non-quota merchandise. Conversely, quota merchandise may or may not require a visa depending upon the country of origin. A visa does not guarantee entry of the merchandise into the United States. If the quota closes between the time the visa is issued in the foreign country and the shipment's arrival in the United States, the shipment will not be released to the importer until the quota opens again. Let's talk about the Electronic Visa Information System, or ELVIS. ELVIS is the electronic transmission of visa information for textile merchandise from a specific country to the U.S. Customs Service. Watches and watch movements. There are no licensing requirements on watches and watch movement entering the United States unless the watches and watch movements are produced in the Insular Possessions, or U.S. Virgin Islands, American Samoa, Guam. The Department of Commerce and the Interior administers a program that establishes an annual allocation for watches and watch movements assembled in the Insular Possessions to enter the United States free of duty, under Statistical Notes 9/15 to Chapter 91 of the Harmonized Tariff Schedule. Licenses are issued only to established insular producers. Further information on the Insular Watch Program may be obtained from the Statutory Import Program Staff, Import Administration, U.S. Department of Commerce. For dairy products. Certain dairy products are subject to annual import quota, administered by the Department of Agriculture, and may be imported at the in-quota rate, only under import licenses issued by that department. Detailed information on the licensing of these products, or the conditions under which limited quantities to the products may be imported without licenses, may be obtained from the Dairy Import Group, Foreign Agricultural Service, U.S. Department of Agriculture.